You're listening to Best Practices with Kenny Berger. On this podcast, we talk with the country's top trial lawyers about their approaches to every aspect of practice, from case selection to closing argument.
Welcome. Our guest today is Scott Frost of the Frost Law Firm. Scott, welcome to the podcast.
Thanks, Kenny. It's glad to be here.
Yeah, man, it's good to see you. You and I have had the chance to spend some time together at different events, be it through things with Nick Rowley or Trial Lawyers University. And you've gotten some amazing verdicts on really challenging cases all over the country. And it's wonderful to have you on the podcast. Can you share with the audience a little bit about how you got your start and what you're doing today?
Yeah, Kenny, my law firm, we're located in Southern California in Los Angeles, but I really got my start as a lawyer out of law school in the United States Army and the JAG Corps. I spent 6 years on active duty. I was a prosecutor and a defense lawyer, and my last duty station was at Fort Hood, Texas, where I did a double federal capital murder case. I handled in the Army as both a defense lawyer and a prosecutor, simple cases from assaults to hot drug piss tests to capital murder. So I had all that experience. And when I got out of the Army, since I had tried so many cases, I think at one point I tried over 50 court-martials, and then I tried cases in federal court as a special assistant U.S. attorney. It was actually kind of hard for me to get a job because I had more trial experience than most plaintiff lawyers, and I'd always wanted to be a plaintiff's lawyer. I never, ever wanted to represent companies or the man, as I would say. So when I got out, I had a tough time actually finding folks that would legitimately give me a shot at being a plaintiff's lawyer. So I found my way to a large plaintiff's firm at the time in Texas called Barron & Budd. And at Barron & Budd, they gave me the opportunity from day one to go out and start trying cases for victims of asbestos. And I've done other things than asbestos, but we specialize in mesothelioma cases, lung cancer cases, and other asbestos-related cases for hardworking folks like my dad who got asbestos diseases.
I didn't know that about your dad. I'm sorry.
Yeah, he passed away from lung cancer a few years ago. He was in the construction trades in California and then got out and was a salesman for a company that actually sold asbestos products. So, asbestos cases are near and dear to my heart, and our firm works really hard to make sure that all of victims of asbestos are taken care of.
And Scott, you've tried these cases all over the country at this point.
I have. I'm actually licensed in 8 different states, and we try cases, and we have cases right now filed from New York City all the way to Hawaii. So we practice all over the country.
Yeah, and that kind of brings us to the main topic that we're going to be discussing today, which is when you're getting admitted pro hoc or when you're practicing in all these different jurisdictions, the best practices that come with it. So for lawyers who are mainly based in South Carolina or elsewhere, at some point, if it hasn't happened yet, it will happen. For many of our listeners, it's happened and happened repeatedly. At some point, you'll find yourself in another jurisdiction or multiple other jurisdictions. There's just so much that goes into it, so many potential landmines, but also so many potential advantages if you can learn the local rules and your way around. So, Scott, kind of take it from there. When you're looking at a new case in a jurisdiction that you perhaps aren't licensed in or you haven't been in before, what are some of the best practices? What do you do?
Well, Kitty, what's interesting is I actually have tried cases in South Carolina where you're located. And the first thing that I do, and I'll just use that case as an example, is you want to make sure that even though if you're like me, you're licensed in a lot of different states, I still want to make sure that you have a good, strong local counsel. And the reason for that, and a lot of folks, sometimes they don't want to share fees. I think it's the best money spent is having a really good local, because what they're going to do is they're going to help me get ready for the trial. Because what I'm coming in to do, and the reason people are hiring me, is I'm going to come in and I'm going to try the case and I'm going to try it to verdict. You don't hire me to try a case to settle. You hire me to come in and try the case to verdict. So the biggest thing that I want to make sure is I have a really good local counsel in place, and they understand the rule and can help me. And the first thing that I do is I call them up and I say, listen, I need to learn the law of your state, because the biggest thing that I have found is that when you come into a new jurisdiction, everybody, the judge, the jurors, even your local, are going to wonder, who is this Yahoo coming in here, this big trial lawyer who's going to tell us what to do? And I take the exact opposite approach, which is I will tell the judges, Your Honor, I'm not from here. And so I need you to tell me how to practice in your court. I've already read your local rules and I understand those, and I may have a few questions about how you do those procedures. And I think it's one of the most important things is making sure you've read their local rules, and not just say that you have, but you have read them. And if they ask you questions, you understand, or you can ask them questions and say, Your Honor, your rule on opening statement says this. What do you mean by that? Because the judges will tell you, they're not shy about, hey, this is how things work in my court. Now, stepping back, though, before I ever even do that, I go back and I look at each state's pro hoc rules. And I will personally, whenever someone has me pro hoc in, I get the local rule on pro hocs. I get the state bar rule on pro hocs. And I look to see what information do they want and need. Like, a lot of states require certificates of good standing. If you're admitted in 8 states like I am, getting certificates of good standing can be real simple or real hard. For example, I'm licensed in Hawaii, which sounds great until you need a certificate of good standing. And you literally have to have someone physically go and get it for you from the state bar. So those are little things that you don't know. And you also need to make sure that your pro hoc application is complete and that you're the one reviewing it. Because I have known other lawyers who had a pro hoc application that a paralegal did, was signed off, but nobody actually reviewed it, and it had some misstatements in it. And you don't want to start out your trial with the trial court saying, wait a minute, your pro hoc application says this, and isn't this true? Or have the defense raise an issue. And so I've seen lawyers actually get sanctioned for that. So in regards to the pro hoc, I make sure I read the rules, I understand the procedures, and I personally review every pro hoc application, and I'm required to personally sign it. I don't let anybody do electronic signatures or anything like that. So that's what I do right as to the pro hoc application.
And Scott, I think you bring up a really important point when you're talking about communicating with the judge. I remember learning this from Rick Friedman years ago in his Elements of Trial book, but about how much judges and courthouse staff appreciate lawyers who ask questions and want to know the rules and want to make sure they're doing it properly versus coming in and kind of cowboying it and creating conflict. And we're showing reverence without being overly deferential. You're establishing, the rules, but you're there to also do it the right way and do things properly for that courthouse. And that's one of those things that might initially almost gain you some advantage over the local folks who that judge might not be in love with for some of their courtroom behavior.
Yeah, no, it's exactly true. And what I also do is, I make sure I had a recent case we were talking before we jumped on here and about about Cleveland, and I had a case in Cleveland. And prior to me showing up, I got the local rules of Ohio. I got the rules of evidence handbook, and I even went on eBay and I got the Ohio Evidence Courtroom Manual. And
Also, for the folks who can't see it, I like that a lot of them are the traditional Cleveland Guardians, used to be Cleveland Indians, Cleveland Guardians colors. Very, very nice red and blue color scheme there.
well, and that's true, because what's interesting is and the reason I have physical books, because a lot of my younger lawyers, they do everything electronically. There is nothing like having a physical book that you've highlighted and tabbed sitting on your counsel table that you grab and look at during the trial, that the court sees you looking at and understanding that you're trying to comply with their rules. And the rules are different. And I mentioned that I got one of these off of eBay. Some of these rule books, particularly the trial handbooks, which I think are great, they're usually really big books, and they're usually called trial lawyer's handbook. Sometimes you can't get the most recent ones because I looked at one that was $5,000, and I was like, I'm not going to pay $5,000 when I'm pro hawking in. I might do it if I probably wouldn't do it, period. But I went on eBay and I got this one for $100. So, it does what I need, which is what I need to know as somebody coming in is, how does the trial practice work? How do you pick juries, and how do you go about the different opening statements and things like that? So the law on what you're allowed to do in opening statements and things like that doesn't change much, in all honesty. And I'll even go in and say, hey, judge or local counsel, this is what I understand as to the rules for opening statement. Is that what they are? Because sometimes the rules say one thing and the practice is different. So I always make sure that I do that when I get there. But prior to that, I do.
You bring up another great point again on the importance of local counsel. I mean, the last thing you want is local counsel hearing you ask about the rules and they either don't know or give you the wrong answer. So if it means, again, paying a little bit more to have the right person or right firm serving as local counsel, I mean, if it's in the client's best interest, for God's sakes, do it.
Yeah, Kenny, the one thing I've learned in this practice, particularly since I opened my own firm, is that there's plenty of pie to go around. It's worth sharing a fee to get information that will help you overall increase the value of a case. Because we all know, as trial lawyers that are doing it, cases are different, get different values based on who the lawyers are, who the firm is, and what the jurisdiction is. That's just the reality. If you can try a case, you're going to get a better value than somebody who can't. And so there's a big piece of pie. And yeah, you might get a little bit less, but it's going to be important. And the big thing that I always go back to is, what is in the client's best interest? Not what's going to get me paid a little bit more, but what is going to get the client the most overall recovery. Because the reason that we're plaintiffs' lawyers is to help these folks who come to us at the hardest time in their life. And my clients, all of them are eventually going to pass. And they're just trying to take care of their families and make sure, we had a case recently where we were doing a deposition of a client, and he needed to finish the deposition, because if you don't finish the deposition, it can't be used if they're gone. And he literally finished it 1 week, and then this week he passed away. And within a week. So we're dealing with clients that are literally being deposed to death. And it's important that we, as lawyers, represent them and their families and make sure they're taken care of. And if that means I'm going to get paid less, I don't care.
Yeah, it goes back to, what's your purpose? And I was at luncheon yesterday, and there was a South Carolina Supreme Court justice who talked about a lesson that when he was first starting out in practice, I don't know, 40 years ago, give or take, was the idea of once a year, once every couple of years going back. And if you've got a copy of the essay you submitted as to why you wanted to get into law school, read it. Don't become totally untethered from the heart, the drive, and the desire to help other human beings, and get caught up in, this being a quote unquote business. Because obviously there's a business element, but, I think, and we talked about this on the podcast a lot, it's a profession first. It's got to be a profession first. One is primary, the other is secondary or derivative. And the paradoxical piece is, as the more we do that's in the client's best interest, even if it doesn't seem like it's in our immediate financial interest, the more money you make over the long term. So if your goal is money, in a paradoxical sense, be more generous.
Yeah, that's, that is true. I have found that you do better overall. I do like that idea of going back and reading what you thought of why you wanted to be a lawyer to begin with. I remember when I was in the JAG Corps, I spent some time in Bosnia. I was actually a defense lawyer in country. We actually tried court-martials in Bosnia. And I wrote my trial lawyers college, TLC, Jerry Spence's college, when it was still together in 99. I wrote my essay there. And, I'm sitting in Bosnia in a foreign country, doing peacekeeping operations where around us are bombed out shelters where little kids couldn't play because there was a minefield literally behind their house. And, I think that essay really got to the core of my being, in that it made me see how humanity can just do the most atrocious things to each other, but that the United States and us as Americans, particularly as American soldiers, we would roll through towns in the middle of the night. And I don't care what time of day it was, when we'd roll through, kids would come running out just to wave to us and let us know that they supported what we were doing in trying to keep the peace, so that they didn't go back and have crazy warfare, and that they could play on playgrounds that weren't mined. And so I think it's always important that we as Americans and we as lawyers remember why, particularly in this day and age, why we do what we do. And plaintiff lawyers, we are fortunate because the people that we represent, they're by far good people that have had bad things happen to them. And they deserve 120, 30, a billion% from us to help them and their families get through these crises.
Yeah. Yeah. And thank you for doing it all over the country, Scott. ProHoc admission is complete. Rule books are in hand as you're approaching trial in a jurisdiction. Again, you've been admitted ProHoc or one you're licensed in, but you're just not there as frequently. Best practices as you approach pre-trial and opening, and you've spoken some to opening.
So, the biggest thing that I found, Kenny, and I did this in South Carolina, I was fortunate that the week before the judge had a similar case that was going to trial. And it was Judge Toll. If you're from South Carolina, she runs the asbestos bar. Great trial judge, really smart. I mean, one of the smartest judges I've ever been in front of. She found things in documents that, I'll be honest, I didn't find, and I know the defense lawyers didn't find, and just whip smart and in actuality, I used her sort of as an example in closing on damages, but that's a different piece to the story. But what I like to do is I like to show up at least a week in advance to the trial, and I like to watch the court if the court has a trial going, because you're going to learn a lot of things about the court. You're going to learn how they do jury selection. You're going to learn how they conduct the trial, what they want from a trial lawyer. The other thing that I like to do during that time period, and I don't listen to a lot of news. I really try to keep, CNN at minimum, or Fox, or whatever you listen to at a minimum in my life. But during that time frame, I will listen to the local news. I'll listen to it in the morning. I'll listen to it at night to get a flavor for what are the issues in the local jurisdiction. I know a lot of trial lawyers in the past would say, read the local paper. I'll do that, but I found the local news is really a good place. And then I'll visit the courtroom, and I'll make sure that I understand the layout of the courtroom. I'll understand the tech to the courtroom, and I'll have my tech person come in early. Our cases are usually longer in length. I have tried them in 4 days, but usually they take 3 to 4 weeks. So you want to make sure you have your tech right and you have your tech person there. And that's where you start building the rapport with the courtroom staff. Because you come in there and you say, we're the next trial up, and we want to make sure that we are respecting your courtroom and whatever procedures you have. And we talk to the clerks, and they'll tell you, they'll be like, well, usually they set up this way. And we'll say, well, we have a bigger screen. Can we set it up that way? And they'll really help you. And I can tell you that I was in federal court in Wisconsin, and, I had a staff person come up to me, and they looked kind of sheepish, and they were like, Mr. Frost, can we talk to you? And I said, well, yeah. Like, am I in trouble? And they're like, well,
for folks who don't know Scott, I mean, you're very disarming. Like, you're a genuinely nice person. So anyways, I apologize for interrupting, but they sheepishly approach and Mr. Frost.
And I'm like, well, I'm okay. Am I in trouble? And they're like, no, but your co-counsel over there, we don't have any record that they're either pro hoc, going back to our pro hoc conversation, or that they're admitted. And the judge won't let them talk anymore. Now, this person had already opened. And I said, I know I must have had this look because they could tell right away. I'm sure I went totally white. And they were like, and I'm like, what do I need to do to fix this? And I'm so sorry. And they were like, listen, we're about to take a break. The clerk is open, will stay open during this time period, but you have to either have a check or cash to pay for the pro hoc fee. And the judge will sign it, but you got to do it right now. And I'm like, so we're scouring around locally. It's funny because we had a good local, and she literally is like whipping out her checkbook, and she's like, what do we have to do? And she now works for me, so it's great. But we ran to the clerk's office and paid the fee, and everything was fine. But if that had been in 99 out of 100 courts, I would have got a scolding too, and might have been sanctioned. And you know what? Should have been. But that's how building those relationships pre-trial. We didn't walk in there like cowboys. We built those relationships. And so those are important things to do to make sure that the staff is on your side and that you're taken care of. The other thing that I do is when the very first time I appear in front of the court, I try to really not argue anything. A lot of times you do MILs the first day, and I'll try to have one of either the local lawyer. I think local lawyers doing MILs is better, in all honesty, because they understand the local law. But I'll try not to argue anything, so that I can sit and listen. And also I want the court to understand that I'm not here as a gunslinger. I mean, I can sling the guns with anybody, but I want them to understand I'm here to show respect, and I'm going to ask the court about my issues, which are going to be voir dire and how they conduct the trial. But on a lot of those pretrial motions, I want the local to argue it or someone else so that I can listen, understand where the court is, and also show due deference and not come off as, oh, here's the big trial lawyer coming in telling people how things have to be.
Yeah. And then Scott, once you get to voir dire, um, are you, when you're conducting voir dire, are you talking about the fact that you're from outside the jurisdiction? How do you handle that piece?
That's an interesting thing because, I was lucky when I was at Barron and Budd that I had Lisa Blue and Robert Hirschhorn. Robert's one of the most preeminent jury consultants in the country. And we talked about that a lot. And, Robert and Lisa used to say, Scott, they're going to figure out right away if you're from here or not. So don't act like you're something that you're not. And so I don't go, hey, I'm not from here. They're going to figure it out. Okay. In most jurisdictions, when I open my mouth, they're going to know I'm probably not from there. But what I do is I want to understand where they're coming from, and I want to get a feel for the community, because when I argue the case, I'm going to say, listen, folks, I'm not from here. And this is going to be in closing, not in jury selection. And I'm pretty sure you folks figured that out. And they'll nod their head. They're like, yeah, we know you're not from here. And I said, but this is your community, and you get to establish for your community what are the rules. How do you go about things? And I'm going to make some suggestions to you. But this is your community, and you get to regulate the conduct here. And it's been a pleasure to be here. And I kind of feel like I'm part of it now. But I'm not from here, and you all know that. And I think when you are straight up with them, but I don't like to do it in voir dire because I think it seems staged. To me, it's like, oh, I'm not. I've seen people do it. I'm not from here. You're gonna hold that against me. You're gonna hold that against my client. I just don't like it. I think people are smart. They're gonna realize that you're not from here. And I think it's an important thing to be genuine to who you are. But don't talk down to jurors. I think that's the biggest thing that I would say that I see trial lawyers do across the country is they talk down to jurors, and jurors are really smart folks. And, sometimes I talk about folks a lot, and I will tell you in Southern California, they look at me like, folks, who are those? And if I get that reaction, I'll say, well, folks, where I come from, that's what we call people.
When Scott, one of the really, I think, important pieces I just want to highlight it is the way that you address not being local doesn't make it about you. You're making it about the jury. You're making it about audience. So it's not that staged, artificial, choreographed, well, I'm not from here, but I hope y'all don't hold that against me, which is all about you, right? Versus, as y'all probably figured out, I'm not from here. But that's not the important thing. The important thing is that the 12 of you are. And the important thing is that the 12 of you, and then again, right into what you discussed in terms of what are the rules here? What is the community here? What is valuable? What's meaningful? What type of community do you want to have? How does that verdict speak to your values and where y'all want to live when you walk here today? Where it's completely about them, and it's like you've said, hey, not only is it not about me, it's about you. And I fully entrust the fact that these universal values that we probably touched upon are things that the 12 of you know to be important, not just in your community, but everywhere.
Yeah, I think, Kitty, that's important. And the other thing that I like to do, and voir dire is an important piece. And the one thing that I will say that Lisa taught me, well, there's a lot of things Lisa taught me, but the big thing that she taught me is, and Robert too, was know your law on voir dire. And I will tell you, most judges in most states don't know the law on voir dire. What is cause challenge? What is enough to get people off? What isn't? What are the statutory disqualifiers? Because there are statutory disqualifiers in some states. You need to know that. And that's where going back to your good local is. And what I do is I say, listen, I'm coming in. I want to know a lot of things, but here's what I need to know. I need to know what is the law on challenges for cause. What is the law in asbestos cases on causation? What is the law on how you approach experts in cross-examination? But knowing the law is very important. And then what I do is I have our folks do a lot of trial briefs. And, I tell them all the time, I'm like, you may get frustrated with us because I will have a trial brief on every issue, and I will have them prepared ahead of time with the caption and everything, so that if that issue comes up, and this happened recently in a trial we had, issue comes up, literally I reach back, hand them a trial brief, and we file it right then. And you should see the judge's reaction when we're like, okay, here's the issue, here's our trial brief, Judge.
Scott, for the audience, do you mind just speaking to the difference quickly between motions in limine and trial briefs?
Yeah, I mean, motions in limine, and this is something that I think a lot of judges and even lawyers miss out on, is a motion in limine is a preliminary ruling on the evidence. And preliminary means the judge could change their mind, but it also means that you, in order to preserve your record, and I'm big on preserving our record, you need to go ahead and offer that evidence at some point. And you don't have to do it to piss off the judge. And I will tell the judges a lot of times, and I'm big on doing offers of proof, written offers of proof, where a judge grants an MIL saying, I can't talk about something. We'll do a short offer of proof saying, expert so-and-so is qualified, and if allowed, he would testify to X. And then we'll file it with the court. So an MIL is a preliminary ruling. The judge rules against you. Remember, if you want to make your judge and the other side concerned that you're going to appeal this no matter what, which I will appeal every adverse judgment against me no matter what. I've set it up with an MIL or an offer of proof. And then once the MIL is there, during the trial, let's say the judge ruled a certain way, certain issues are going to come up as to what is the scope of examination? What is an expert allowed to say? What are the rules on experts? So a trial brief is not an MIL. It is basically a short rendition of, hey, this is the issue, here's the law. I like to have them on every distinct issue so that it's not complicated. They're very short. The judge can take it back with them in chambers, and in 5 minutes they can read it and go, oh, they're right. The other thing is that it trains the judge and the other side to know that not only are you prepared, but you're setting this case up for appeal. And there is not a judge that I've ever been in front of that wants their name next to an appeal that says reversed. And so when you train them to know, hey, these lawyers are not only well prepared, but they're trying this case for appeal. I even recently had a judge who's like, I filed a bunch of trial briefs, and I said, well, Your Honor, I just want the court to know, I'm making sure my appellate record is clean. And the judge literally is like, well, I'm not sure you're going to have to worry about that. I took that as a good sign. So
that is a good sign. It's a very good sign. We've talked some about voir dire. We've talked some about opening. When it comes to other aspects of opening or witness examinations, what should folks know best practice wise when they're entering a new jurisdiction or unfamiliar jurisdiction?
Well, I tell you, the biggest thing on opening, and that's why I get the rule books or the trial lawyer's handbook is it an opening argument like it is in Texas, or is it an opening statement like it might be in California? And those are hugely different. Now, I will tell you that I have come around, and I think David Ball is one of the people that really first started advocating this in his damages books, was don't advocate too early. And I've come around, particularly since I practice a lot in California, to in the opening make it just the facts. But in Texas, you kind of look like you don't know what you're doing if you don't argue a little bit. So I might argue a little bit there. But the other thing that I learned really early, my first civil trial, we were in Louisiana, and it was back in the day when lawyers had just first started using PowerPoints. And we had a beautiful PowerPoint set up, professionally done. It was in the days when we weren't doing them ourselves. We now do them ourselves. And we had this great PowerPoint. The defense objected, and the judge said, well, no PowerPoints. But fortunately, the lawyer I was working with, he had thought ahead of that. And we had taken literally the PowerPoint and we'd taken it on a flip chart and hand wrote it out. And so the judge was used to flip charts, didn't let the PowerPoint, and everything went great because we just flipped through it. So when you're looking at openings, it's important to know what the rules are, what the procedures are, but also have a backup. The other issue that I've run into a lot is whether you want to use videos in opening. You might have depositions that are ruled upon. In my view, if they're factual, why not use them? Sometimes they can be used effectively. So you need to know if the judges will use that. California, the judges, their heads spin off if you try to use a video in opening. Even in closing, they don't like it. That, time limits, those things. So that would be opening.
Thank you. Yeah, and one of the things is you've been talking, we've talked about before on this podcast, but I remember hearing the saying when I was in law school, those who know the rules rule the day. And here, the knowledge of the rules, the knowledge of the law, understanding in essence what the rules of engagement are going to be, and then how best to present your case within that context. I mean, it speaks to the amount of work you put in, the discipline, and certainly just from a best practice standpoint, knowing where the lines are and being as creative as possible within those lines. It doesn't mean you're confined. In fact, it means you can potentially be more creative by knowing, what's in bounds and what's out of bounds.
Yeah, I think you're exactly right. And, one of the things that I found is, particularly in jurisdictions, these rules vary like experts. When you cross-examine experts, our practice is very document intensive. We have a lot of studies, and you want to use studies to cross-examine. Well, each jurisdiction has a different way of doing it. Some jurisdictions will allow you to actually quote from articles. You can put them up on the screen, and the expert can basically parrot what the article says. Well, you can't do that in California. California and some other states out west, all you can do is the expert can give their opinion, and they can state what the basis of the opinion is, and the judges say the article itself is hearsay. Well, if you're used to a jurisdiction where you can throw up the article and have the expert basically parrot it, and you're not ready for the way that California does it, then your examination is going to go really haywire. The other thing is, if you want to use articles on cross-examination with the other side, in places like California and Washington and Oregon, you have to do different procedures. California, for example, you have to have an expert that says the article is authoritative. And not just that it's authoritative, that they relied on it, it's reasonably relied upon by experts in the field. And there's a whole foundation to do. And if you don't get it all, you don't get to use the article on cross-examination. And I'll be honest with you, a lot of judges don't know these rules because they don't use them all the time. I probably know the rules as well or better than they do because I use articles in every cross. And so that's an important thing. The other thing is when you're trying to get exhibits admitted, a lot of our exhibits and articles and things are going to be ancient documents. Well, not every jurisdiction has an ancient document rule. California doesn't have one. The federal rules do. So you need to know that. And the other things like Florida has certain rules about whether you can bolster a expert's testimony. And I'll be honest with you, sometimes I got halfway through one trial and I had tried to figure out the rule and it never made any sense. And then a case came down literally during the trial that said that everything that we had done before wasn't the right way and you needed to do it a different way. And, I'm sitting there going, what am I going to do? So, you can prepare as much as you want, but those are the basic things you really got to know in the trial itself before you get to closing.
And Scott, again, just to highlight it, I mean, so much of what you're talking about goes back to the preparation that you've done, anticipating the issues, anticipating the evidence, anticipating testimony from the defense folks and otherwise. What does it look like in terms of your approach to trial prep? Because obviously it's something that you pride yourself upon, but can you just speak in general terms about your approach to trial prep?
Well, the one thing that I do and is that when we're, most of these trials, as you can tell, they're going to be long trials. We're going to have a war room where we're going to have, everybody together collectively. What I try to do is one of my requirements in the war room is that we have a picture of the clients in the room, not on your computer. We blow it up, put it on the wall. And I usually like to have it where you're going to walk out every day. And I want everybody in that room to remember why we are there. And so the first part of my preparation is getting my head straight about why I'm there. And Rick Friedman talks about this a lot in a lot of his books about why am I in this courtroom on this day? There may be other lawyers that are better at being a lawyer or a trial lawyer, but I'm the one who is here right now. And how am I going to give this particular client the best of what I am right now? Not the best of me last year, not the best of me in 2 years, but what's the best that I can do right now? And I try to keep that in mind as I'm preparing for the case, in that, at some point you have to take the time. This is something that I've learned and really tried to apply recently, is sit and think about, why am I here? And why is this case important to the client and to the jury? Because the jury, you've got to get them to care. And the only reason that people are going to care is if they think they can make a difference, and that difference they see in their community, and they kind of are sitting there going, you know what? This just isn't fair that this happened to these folks, and I'm going to help fix it. Because I think the jurors want to genuinely do the right thing, and our role is to make sure that we give them the information and the ammo to do the right thing. And as plaintiff lawyers, if the jurors follow the law, we should win almost every single case.
Well said. Well said. Scott, with the time that we have left, we've got a little bit, but let's go to closing.
So, the biggest thing on closing, and a lot of this stuff I've honestly learned through trial and error. I tried a case where I showed up the morning of to do closing, and everybody had PowerPoints, and the defense wanted to exchange PowerPoints. And I'm like, opening statement, we exchange PowerPoints, but this is closing argument. Like, what do you mean exchange PowerPoints? And, it turned out that that's kind of generally what the practice was. It wasn't in the rules. And, it was one of those situations where I was totally taken off by it. And, I made the mistake of continuing to say, no, I'm not going to do it. And, eventually in the post-trial motions, it became a big deal. Oh, they didn't share the PowerPoints. It made no difference in what that jury did. Zero difference. You cannot convince me otherwise that they would have done anything different. But I gave the defense an issue in post-trial motions when we got a really nice verdict to, chip away at it and to say, well, they didn't do this. These out-of-state lawyers didn't exchange PowerPoints in closing. So, go back and make sure you know those rules. The other thing on closing that's really important is you need to know the law on damages. And, depending on where you're from in the country, some places let you give a number, some don't. And Philadelphia is a perfect example. You cannot tell the jury what the number is that you want, which I think is crazy, to be honest. How is jurors that are coming in that have never seen a case before supposed to know that this case is $1 million case or a $10 million case without the lawyers at least helping them or explaining to them?
Quick question. In Philadelphia, can the defense attorneys tell the jury to bring back nothing? I mean, in essence, tell them the number is zero?
Yes, and that's the frustrating piece. And
Wow.
Kenny, that's the way that when, one of the issues in California is whether you get to talk about a number in jury selection. And, I've argued this many times because, I do think it's important when you can say, listen, we're here and we're going to ask you at the end of this case, because we believe the facts and the evidence support it, of a verdict in the range of $50 million. Anybody here having a problem with a verdict of that size? And judges, their heads spin off, and I think it's because they're concerned whether they're going to get a jury or not. But the real thing on our side is that, there's a huge difference between somebody saying, oh, I can award $1 million or I can award $50 million or even $10 million, because what you'll hear them say when you have a number, whatever that number is, they'll say, hey, well, I might be able to do 10, but 50? Oh, well, there are $10 million cases and there are $50 million cases. And so, that those numbers are important, but it's also important when you're arguing that where you want to talk either in voir dire or opening statement and give a number, is you say, Your Honor, I picked a lot of juries and I can't remember a single one where the defense didn't get up and say, can you give a defense verdict? Can you award zero in damages? And I have to go, Judge, zero is a number. Or if they say a defense verdict, that's really zero, which is a number. And so it's not really fair that they get to give a number and we don't. And so the nice thing about that is if the judge doesn't let you give a number, then the judge doesn't let them get to say zero. So it is an important piece when you're talking about damages, because I do think it's important to be straight up with them. Hey, this is an important case, and we're going to be talking about not only tens of millions of dollars, because, I will say sometimes that the judge won't let me give the specific number, tens of millions of dollars, and they'll come back and say, well, are you talking 100 or 200? Well, does that make a difference to you? So.
Yeah. Yeah. And again, just going right back to knowing the rules, knowing the law, working to get a verdict, and perhaps more importantly, a verdict you can keep.
Yeah, I think keeping the verdict is the big thing that, is important is, we try these cases and we want to win. But you always have to keep in your mind, hey, you want to keep the verdict. You want to do what's right by the clients. And, particularly in this day and age where the verdicts, according to the defense side are nuclear or they're too big, you want to not give them the opportunity on a stupid issue like not exchanging your PowerPoint to get a nice verdict overturned. We as plaintiff lawyers need to make sure that we protect our verdicts as best we can, because I don't think there's anything like a nuclear verdict, to be honest. I think that these cases have been undervalued for years. And I think what happened was during COVID, people learned that intangible things are worth a lot of money. If I'm stuck in my house for 2 weeks, what's that worth? I mean, just to be able to get out. And I think that's been the major change. It's not anything that we're doing. I think that we're better as a plaintiff's bar at presenting our evidence. But I think that's what's happened is society has realized that these intangible things, like not having to think about every time I go to the doctor, am I going to get a bad scan, are very, that's worth a lot of money. Think about how much you would pay to not have to do that. So I think that those are all really important things.
Yeah. Maybe last question on this end. When it comes to post-trial motions, are you, I think I know the answer here, but are you traveling back to the jurisdiction to argue those post-trial motions, or how do y'all handle the post-trial aspects?
What I usually do is I will do like I did at the very beginning. I kind of bookmark it. I will come back and be there, but I will not be the person that argues it. I will either have a local or I will hire a appellate person, because again, I want the court to know I'm going to appeal if you do anything adverse. So I may go out and hire a high caliber, individual to argue the post-trial motions. So I think that's, again, money well spent, where you bring somebody in from the outside to be like, hey, judge, we're setting this up. We're ready to go. The trial lawyer is sitting here, but, we are the appellate lawyers, and we're going to make sure that this thing is held up.
Yeah. Yeah. I mean, let appellate lawyers be appellate lawyers. Let local counsel be local counsel.
Absolutely.
Part of the same team. Scott, this has been fantastic.
Well, thank you, Kenny. It's been a real pleasure to be on. I really enjoyed your podcast, and I really think that the nice thing about this podcast versus a lot of lawyer podcasts is it's real practical advice that hopefully plaintiff trial lawyers can go out and use and help represent their clients and get justice for these folks.
Thank you. Yeah, I mean, the entire idea with this podcast was how do we go about collecting the best practices from different lawyers all over the country to make the plaintiff's bar as a whole better, and by extension, create a rising tide of civil justice. Scott, for folks who want to get in touch with you, are you doing exclusively mesothelioma cases?
No, we do a little bit of everything. We do a lot of products liability cases. We've done benzene cases. I've done hip defect cases. I've done Roundup cases. We do anything that requires a trial. We also do some PI stuff. And the best way to get in touch with me is to email me. It's Scott, SCOTT, at Frost, FROST, lawfirm.com. Or if you want to call me on my cell or text me, that's fine too. It's 214-862-9013. And anytime there's somebody that needs help, even if you just need some questions answered about, hey, how do I try a case in California? Hit us up, because we want to make sure that we are helping folks try these cases and help their clients out.
Yeah, and again, you're barred all over the place. You've got you're admitted in 8 states, or licensed in 8 states, I should say.
Absolutely. And we also practice everywhere else, obviously through Pro Hoc Vice. And, I mentioned that we have cases filed in New York. We've been in Florida, Georgia, Texas a lot, everywhere across the country. We'll go anywhere to try a case and help represent these hardworking families.
Thank you, man. And Scott, thank you for taking time to share some of your knowledge, to share some of your experience. I mean, one of the things I've really enjoyed about this podcast too is it's coming from experience. You're not spouting theory. You're not giving advice. You're speaking from being in the arena. So thank you, sir.
Well, thank you, Kenny. I appreciate it.
All right. Ladies and gentlemen, this has been Best Practices with Kenny Berger. Our guest today, Scott Frost. Fantastic trial lawyer and friend, and we look forward to being with all of you again soon. Take care. Thanks for listening to Best Practices with Kenny Berger. This podcast is produced by my law office. We are a trial firm based in South Carolina, focused on life-changing injury and wrongful death cases. Here's the deal. If you find these conversations useful, if you think they've benefited you or might help somebody else, please follow the show and share it with other trial lawyers who might appreciate it. Lastly, thank you so much for listening, and we look forward to seeing you next time. Take care.